litigation. The purpose of this is to make you disclose other people that you believe were involved in the accident. So all parties can know about this at the inception of the case, not find out much later.
So explain that in terms of giving notice to the opposing party in a litigation. What do you mean by that?
So there's a complaint which the plaintiff files that's answered by the defendant, but it's very basic information. So the purpose of initial paper discovery like this is to kind of flesh out what claims for the plaintiff or defenses that a defendant may bring in a case. So, for instance, the Pino'S attorneys can fashion their discovery plan, what witnesses they want to depose, and that sort of thing. So these are required to be answered such that, as a defendant, the Pinos would be giving fair notice to the plaintiffs of their position with regard to the cause of the accident or contributing cause.
And if Mr. Pino's recollection at that time was that there was another boat that may have contributed to him losing control of the vessel, if that's his recollection, was he obligated to notify or to respond to that in the questions propounded in the interrogatories?
Oh, absolutely. That's the purpose of these questions.
Okay. Let's see if there's any others. I think that's it. Can you take that back from me?
Sure.
At the end of the interrogatories, it is signed by each of the parties, Mr. Pino and Mrs. Pino, respectively.
Correct.
And there's a declaration that each makes that it's under penalty of perjury under the laws of the United States of America that the foregoing interrogatories are true and correct to the best of my knowledge on a particular date.
Yes.
And do you recall these interrogatories were signed in October of 2023?
Yes.
And even what happens, well, let me take that back. Mr. Pino was obligated to give his best recollection at that moment in time?
Yes, on the variety of issues in the interrogatories. There's legal questions, factual questions, a mix of different things for both liability and damages.
And Mrs. Pino, could she rely upon his recollection in responding to the interrogatories propounded upon her?
Absolutely.
If I could just have a moment. Judge, those are all the questions I have at this time.
Thank you. Mr. Mescalato, good afternoon again.
Good afternoon.
You indicated that the answers that you just read now for us are a question of mixed law and fact, right?
Some of them.
Okay, and so like questions about how did the crash occur, is that one of the questions that you would say is a mixed question of law and fact?
I'd have to look at which question you're talking
Sure.
about. I don't have them committed to memory.
So I'm going to show you State's Exhibit 12, which is an evidence, and this is the interrogatory that was entered on behalf of the defendant, in this case, George Pino, who is that man there in the light blue tie, right?
Yes.
For the record, identifying the defendant. There was a question that was asked, number 5, describe in detail how the incident described in the complaint, meaning, of course, the crash, happened, including all actions taken by you to prevent the incident. And what he says to answer that question, basically, not to put it in legalese, but like maybe everyday language, is what I said to Lieutenant Thompson, yeah, that's how the incident happened. Is that fair, accurate?
Yeah, that's what it says.
Okay. And is that what you would consider a mixed question of law and fact, or is that just a question of fact? How did this happen?
No, that would be a question of fact.
Okay. And then number 6, describe in detail each act or omission on the part of any party to this lawsuit that you contend constituted negligence that was a contributing legal cause of the incident in question. The wake of the unidentified vessel heading northbound was a contributing legal cause of the incident in question. That's asking for facts too, right?
That's a mixed question of law and fact.
Okay.
It's asking for contentions concerning negligence and various other points
So,
there.
so the answer is saying, I'm not necessarily the one at fault. This other vessel was the one at fault.
No, that's not what it's saying.
It's saying that constituted negligence, right? So the other vessel was the negligent vessel?
No, it's saying negligence is, it's different than criminal law. Many people describe it like a pie. 100% of the fault for an accident gets divided between the participants. That interrogatory is simply saying that the unidentified vessel bears some, we contended that the unidentified vessel bears some percentage of the fault for the accident.
Right, but if there was no other vessel, then this would be an inaccurate statement, correct?
I don't believe it would be inaccurate.
If there was no other vessel that contributed to the cause of this crash, then saying the wake of the unidentified vessel heading northbound was a contributing legal cause, that would be an inaccurate statement, correct?
That's Mr. Pino's recollection.
Well, that's what he told you was his recollection.
Correct.
Because you obviously would not want to put into a court file a pleading that was, from your vantage point, untruthful, right? You're an officer of the court.
Correct.
And so you have obligations when you file a document that what you're filing in good faith you believe to be accurate.
Yes.
And you thought in good faith that you could trust that what your client was telling you was truthful, right?
Yes.
Now, if an interrogatory is posed to a party to a lawsuit, hey, how did X happen? If that party does not know how something happened, that party can answer, I don't know the answer to that question, can't they?
They could.
And so when Cecilia Pino was asked about how the crash happened, she could have answered by saying, I don't know because I wasn't watching when the crash happened. She could have answered that, correct?
She could have.
But she didn't, did she?
No.
Now, you indicated that Mr. Pino wanted to do everything he could to resolve the claims, right?
Yes.
Okay, but that's not really true, is it?